Hi there, I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. This lecture will introduce you to mergers and acquisitions in an area. This is an area where many paralegals work. Topics include statutory mergers, share exchanges, asset and stock acquisitions, and entity conversions, as well as amending the articles of incorporation. More specifically, these are the lecture objectives. Mergers and acquisitions take place in the U.S. with increasing frequency, and there are all the mega mergers, those that are valued in excess of $1 billion, make the headlines. More common mergers are those that take place between smaller corporations, including those that are closely held. The Business Corporation Act of most states includes provisions for statutory mergers and share exchanges between corporations and between corporations and other types of business organizations. Statutory mergers and share exchanges may be between domestic corporations or domestic and foreign corporations. And mergers may also involve non-corporate entities such as limited liability companies. So what is a merger? It's a combination of two or more corporations whereby one of the corporations survives, the surviving corporation, and the other merges into it and ceases to exist, the merging corporation. The shareholders of the merging corporation usually give up their shares of stock and receive shares of the surviving corporation in return. They then become shareholders of the surviving corporation. When a subsidiary corporation merges into a parent corporation, it is referred to as an upstream merger. When a parent corporation merges into a subsidiary corporation, it is referred to as the obvious downstream merger. A triangle merger involves three corporations. A subsidiary corporation is used to acquire a target corporation. The parent corporation funds the subsidiary corporation with cash or shares of stock. The target corporation is then merged into the subsidiary corporation. Okay, so the parent and the subsidiary corporation are both surviving corporations. In a reverse triangle merger, the subsidiary is merged into the target corporation, which then becomes a subsidiary of the parent corporation. This target corporation and parent corporation both survive. In a statutory share exchange, all of the stock of the target corporation is acquired by another corporation, which becomes its parent corporation. A lot of fun puzzle pieces. State statutes usually address these important areas of mergers and exchange, requirements for the plan of merger or plan of exchange, the specified method for adopting a plan, requirements for articles of merger, what should be included in them, requirements for filing of the articles, provisions regarding the effect of the merger or share exchange, and provisions for short-term mergers, etc. And the review notes, lecture notes have all of this listed out. So mergers and acquisitions must comply still with the federal antitrust laws. Both the Federal Trade Commission and the Department of Justice have responsibility for overseeing it. Just fix something real quick on my notes. The FTC was created by the Federal Trade Commission Act. It happened in 1914. Created to guard the marketplace from unfair methods of competition and to prevent unfair or deceptive acts or practices that harm consumers. The FTC identifies and challenges anti-competitive mergers. Mergers and acquisitions may be subject to the anti-monopoly provisions of the Sherman Act and the Clayton Act. Section 7, specifically of the Clayton Act, called the Scott-Hart-Rodino Antitrust Improvement Act of 1976, provides that notice of certain contemplated mergers and acquisitions must be filed with the FTC before they're completed. And as of 2011, pre-merger notification under the Hart-Scott-Rodino Act is required for certain mergers and acquisitions valued at more than $53.1 million. When a merger or plan of exchange between two unrelated parties is contemplated, the two parties generally spend time to negotiate the transaction and then enter into a letter of intent that outlines their intentions. The plan of merger and plan of share exchange is typically required by state statutes to conduct merger or share exchange transactions. And a plan of merger or plan of share exchange typically sets forth the agreement between the merging corporations or the corporations involved in the share exchange. So statutory mergers and statutory share exchanges, as well as the sale of assets or all of the stock of a corporation, require approval of at least a majority of the shareholders of the corporation. Shareholders who object to a corporate merger or acquisition may be eligible to dissent and obtain payment for the fair value of their shares. Articles of merger or articles of share exchange are executed and filed with the Secretary of State or other authority, and that will affect a statutory merger or share exchange. The areas covered are listed here that go into the articles. Next slide. Due diligence and pre-closing matters. The investigation and examination of documents prior to the closing of a merger or acquisition transaction is referred to as the due diligence process. Due diligence refers to the standard of care that must be exercised by each responsible party. In addition to reviewing the documents provided, due diligence often involves on-site investigations to inspect the real estate, buildings, assets, and inventory involved in the transaction. At closing, the merger or the closing portion is the merger and exchange. Closings are often attended by key officers and shareholders from each corporation, and attorneys, paralegals representing both of them. The following these areas are covered: the shares exchange hands, their assignments and transfers and contracts signed, cash is paid to the appropriate folks. It's like a closing. Contracts for all future obligations are given to the appropriate individuals. So that's closing, pre-closing, and closing. And then there's post-closing. I thought I had it in my notes, just not here. I do. There are typically several post-closing matters to attend to. That includes documents be filed at the state. It's like the post-closing of a real estate transaction, get everything filed and sorted out and checks written and that sort of thing. All right, asset and stock acquisitions. So one corporation may acquire another by purchasing all of its stock or assets. And if a corporation is acquired by the purchase of all of its outstanding stock, the acquiring corporation typically assumes the obligations and liabilities of the target corporation. If a corporation is acquired by the purchase of all of its assets, the acquiring corporation typically assumes only the obligations and liabilities of the target corporation specified in the purchase agreement. So the difference is purchasing all of its outstanding stock versus all of its assets. So two different scenarios there. of asset and stock acquisitions. When a corporation attempts to purchase or take over another corporation against the wishes of the management and board of directors of the target corporation, the transaction is referred to as a hostile takeover. And shark repellents are a defensive measure that's adopted by a corporation to deflect these hostile takeovers. And the de facto merger doctrine allows the courts to view the transaction as a merger if it has the characteristics of a merger, regardless of what it's called, to prevent an injustice to third parties. The procedures for asset and stock acquisition, preliminary negotiations take place, assets and a purchase agreement is written very specifically as to what assets are going to be acquired. The detailed stock purchase agreement sets forth the terms for the purchase of the corporation stock. It's also going to tell us the details concerning the corporation to be acquired. And that's it. Okay. So entity conversions happen, and the state statutes generally provide for the conversion of corporations to non-corporate entities and for the conversion of non-corporate entities into corporations. Conversions are generally, they require the consent of the owners of each entity and the board of directors and managers of each entity. And statutes are also going to provide for domestication, which is the procedure to change a corporation's state of domicile, and generally requires the approval of the board and shareholders. Articles of incorporation are sometimes amended, and when it changes, the articles must be filed with the Secretary of State or other official. And under most circumstances, the amendments to the articles of incorporation require the consent of all shareholders. The paralegal's role, there's quite a bit, and even more on the next slide. And all this is also included in our review notes. So there we have it. Thank you. I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.